morning, everyone. Thank you so much for joining us today for part 2 of our Fair Housing and Tenant Rights training series. We're just going to give it a couple of minutes as people start trickling in. So as I just said, this is a training series. We had part 1 last week on tenant rights. And then today we have Laura and Anna from Bay Area Legal Aid covering fair housing. And then next week is our final part of the series, which will be an eviction overview. So my name is Nicole Thomas. I'm from Homebase. I'm a policy analyst and I'm joined by my colleague, Buli. If you want to introduce yourself.
Hello, sorry I'm off camera, but it's lovely to see everyone. I'm a senior staff attorney at Homebase, and I'm happy to be here for a bit of the training today. Thanks for being here too.
And for those of you who don't know, we as Homebase, we're a technical assistance provider, and we provide TA to COCs across the nation. And really, we do a lot of work in the Bay Area. And so in Santa Clara County specifically, we work with the Office of Supportive Housing. And one of the many things we do is provide a suite of annual trainings. And the Tenant Rights and Fair Housing training series is one of those trainings. Now I'll hand it over so that Laura and Anna can actually briefly introduce themselves, and then we'll go over some tech.
Oh, hi, good morning, everyone. My name is Laura Vera. I am an attorney with Bay Area Legal Aid in our Santa Clara County Regional Office, and I'm in the practice area of housing.
Hi, y'all. My name is Anna Ratner. I am also a staff attorney at Bay Area Legal Aid, and my practice area is also housing.
Thank you both. We are so happy to have them both as real experts to talk us through fair housing. And for today, just want to go over some quick Zoom features. So we do have closed captioning available. You all should be able to see that live transcript option. It is enabled currently, but please let us know if you're having any trouble getting the subtitles. You can just privately send me a message or send a message to everyone, and I will assist you shortly. So for today, we're going to have everyone be on mute just to minimize background noise, but we are definitely going to be actively monitoring the chat. So please feel free to pop your comments and questions at any point, and we'll be attending to the chat regularly. Sorry, I haven't updated the slide. If you have tech issues, please send a direct message to me through Zoom or our team email, or you could send a message to Lily as well. And another thing I want to make note of is we did send the slide deck by email yesterday, but to anyone who didn't receive that, the recording along with all of the training materials will be available to everyone who attended. It's going to be posted on the COC training page, and we will send an email out notifying you when those materials are ready. So again, all of the materials and the recording will be available to all of you, and I will send out an email when those are available. So again, we're really going to ask for engagement through the chat box, and we have quite a few poll questions today, and those are just quick comprehension checks. They're completely anonymous, but we really do invite you to engage in those comprehension checks. So without further ado, let's have a quick icebreaker for today. So just to familiarize ourselves with the chat box, please pop in your name, your organization, and then your favorite fall activity. Thank you. Okay, so while people are maybe pondering their favorite fall activity, I will switch over to their slide deck. Okay, I'm seeing a lot of watching movies, pumpkin pie. Nice. The heater, okay. I feel that. Okay, here your legal aid, take it away.
Great, thank you, Nicole. I'll go ahead, Anna.
I think Nicole already covered the material of this opening slide, but this is our part 2 of our training, fair housing. And here's our agenda for the day. A brief overview of Bay Area Legal Aid, our services, client eligibility, and how to access our services. And then the substance of the day's training, fair housing overview. We'll be covering fair housing laws, protected classes, prohibited conduct, reasonable accommodations, source of income discrimination, and protections for immigrant tenants. Next slide.
Great. So just a little bit about Bay Area Legal Aid. We do provide free legal services to eligible low-income residents in the Bay Area. We cover different practice areas. The practice areas in Santa Clara County include housing preservation and homelessness prevention, which is what Anna and I do. So we assist clients in addressing any landlord-tenant matters, defending against illegal evictions, asserting rights under fair housing laws, which we'll just go over in today's presentation, and combating discriminatory housing practices. We also assist clients with subsidized housing issues and preserving their, for example, Section 8 vouchers or low income tax credit units. We also have an immigration practice area, which provides services to immigrant survivors of domestic violence. Some of the services include VAWA self-petitions, U-Visa petitions, temporary restraining orders, and other services for survivors in conjunction with our domestic violence practice area. We also have a health consumer center, which assists clients with navigating services from public and private health insurance programs, such as Medi-Cal and Medicare, or county health programs. And then we also have a domestic violence and sexual assault prevention unit, which assists domestic violence survivors with obtaining temporary restraining orders, divorces, child and spousal support orders, safe custody and visitation orders. We also have an economic justice unit, which helps clients obtain access or address wrongful terminations or denials relating to income support programs like SSI, SSDI, general assistance, food stamps, CalWORKs, and other programs. And then we have a consumer law unit, which is currently not staffed. We have a regional unit in all of our Bay Area regional offices. And these attorneys assist with consumer-related issues like fair credit reporting, fair debt collection practices, and also bankruptcy counseling and advice. And lastly, we have an also understaffed youth justice unit right now, which that area is a general practice area that focuses on our youth population and assists in areas like foster care, health access, SSI, education, housing, and homeless youth services.
Still muted. All right. And for clients to access our services, they should call the legal advice line number is up here. That can be for advice in any of our practice areas, or if they have a health center issue, then they can call the Health Consumer Center line, which is dedicated to that practice area. Next slide.
So, and before we get to just the fair housing, I realize that we may be missing just who's eligible for our services. So real quickly, those that are generally, we do have income and eligibility requirements and citizenship or immigration status eligibility requirements. So we do provide assistance to low-income residents that are generally at or below 200% of the federal poverty line, except for the Health Consumer Center work. There's no income requirements at all. So if someone makes over 200%, that's fine. We can still assist those callers or prospective clients. And also, we only, unfortunately, due to our funding, we assist eligible immigrants and those who are U.S. citizens. Eligible immigrants include those with permanent residency or applying for permanent residency, or if they have a U visa, or they are a survivor of domestic violence, human trafficking, sexual assault, or violent crime. We also assist refugees and asylees as well. So now get into fair housing laws. Next slide, please. Thank you. So there are different federal and state fair housing laws that prohibit discriminatory housing practices. And each of these laws provides protection from discrimination, and some of these statutes are broader than others and provide for larger protections, especially when it comes to protected classes, which we will go over in the next slide. So first, oh, sorry, go back. Thank you. So under federal law, there's the Fair Housing Act. This was passed as part of the Civil Rights Act of 1968. It was actually passed 1 week after Reverend Martin Luther King Jr. was assassinated. The Fair Housing Act provides it prohibits discrimination in the sale, rental, and financing of housing based on race, color, religion, and national origin. Sex was later added as a protected class. And the Fair Housing Act was later amended with the Fair Housing Amendments Act to include disability and familial status as a protected class under the Fair Housing Act. The Section 504 of the Rehabilitation Act was enacted in 1973 and was actually the first disability civil rights law passed in the United States. It specifically states that no otherwise qualified individual with a disability in the United States shall, solely by reason excuse me, of his or her disability, be excluded from participation in, be denied benefits, or be subjected to discrimination under any program, service, or activity that's receiving federal financial assistance, or under any program or activity conducted by an executive agency or the United States Postal Service. So this means that Section 504 prohibits discrimination on the basis of disability in any HUD program or any programs that receive HUD funding. And then the last of the federal laws is the ADA, Americans with Disabilities Act, which prohibits discrimination on the basis of disability in all programs, services, or activities of public entities and private entities that own, operate, or lease places of public accommodation. So this would include shelters and hotels. Under state law, we have California's Fair Employment and Housing Act, which prohibits discrimination in housing and provides similar protections and broader protections than the Federal Fair Housing Act. And there's also the Unruh Civil Rights Act, which provides protection from discrimination by all business establishments in California, including housing and public accommodations. So the general purpose of all these laws under federal and state is just to prevent discrimination in housing by making it illegal to disadvantage someone in renting, buying, or occupying a home because of that person's membership in a protected class. Next slide, please.
Every time. On this slide, we have a list of which classes of persons are protected under federal law. The protected classes are race, color, religion, sex, familial status, national origin, and disability, whether physical or mental. California law protects all of those classes, as well as marital status, ancestry, sexual orientation, gender expression, and gender identity, source of income, medical condition, genetic information, and military or veteran status. And just a little footnote on the federal law, protected class of sex, based on a recent decision in the Supreme Court, Bostock v. Clayton County, I would say there's a strong argument that the Fair Housing Act probably also prohibits discrimination based on sexual orientation and gender identity, since the Supreme Court found that in a different federal right, in a different civil rights statute, protections based on sex included those protections. So we'll see how that plays out. The Fair Housing Act specifically states that it's unlawful to print, to publish discriminatory advertisements for the sale or rental of housing units that indicate any preference on the basis of these categories. And that applies to not just newspapers, magazines, radio, television, but also to advertising agencies, sales firms, real estate professionals, and management companies. So if a classified ad, a display advertisement, an insert, or any other type of real estate advertisement is published with discriminatory language, the person or the agency that placed the advertisement will be liable, along with the publisher that printed it. Next slide, please.
So next we'll go over just a hypothetical. We'll do the poll function. So the first question, the first hypo is Tammy, tenant, believes that her landlord is discriminating against her because she is Native American. Is Tammy, tenant, a member of a protected class and therefore entitled to enforce her rights under fair housing laws? Yes or no? Give it about 5 more seconds. Get your last votes in there. All right. So yes, 100% of you said yes, and all of you are correct. So Tammy is a member of a protected class under both federal and state laws. Here, the protected classes could include, for example, race, color, and national origin. Second hypo on the slide. So Tammy, tenant, believes that her landlord is discriminating against her because of her veteran status. Tammy is a member of a protected class under which laws? So A, the Federal Fair Housing Act, B, California's Fair Employment and Housing Act, B, both A and B, or D, or C, none of the above, D, both A and B. Or those are reversed, but you guys know what to do. Give it 5 more seconds. Get your last votes in there. Almost at now we're at 50%. All right. So the majority of you guys answered both A and B. The correct answer is actually B, California's Fair Employment and Housing Act. So veteran status or military status is actually not a protected class under the Federal Fair Housing Act. It is a protected class under California's Fair Employment and Housing Act. So if Tammy did want to assert her rights for being discriminated against on the basis of her veteran status, then she has the right to enforce her rights with a DFEH complaint, which is the California State Agency, where she can file a complaint. But yes, unfortunately, and it is surprising because veterans are all over the United States, but it is not a actual protected class under the Federal Fair Housing Act. Next slide, please.
All right. Tammy, tenant, has a HUD VASH voucher and wants to rent a unit owned by Larry, landlord. When Larry met Tammy, he thought that she would be a good tenant. After finding out that she had a HUD VASH voucher, Larry then told Tammy that he couldn't rent to her because he didn't want to rent to a veteran with PTSD. Larry, landlord, has discriminated against Tammy based on her membership in which of the following protected classes? And race, B, gender, C, disability, D, veteran status, E, both C and D, or F, none. Just a few more seconds. Get your votes in. All right. So most people picked the right answer, which is D, or sorry, I can't count or read. Anyway, which is E, both disability and veteran status. Even though the facts in the hypo don't specify that Tammy had PTSD, you can discriminate against somebody based on your perception of them having a disability. And so if Larry Landlord believed that Tammy had a disability and discriminated against her for that reason, that is enough to trigger the protections. Next slide. Oh, and then I guess sort of depending on, you could probably also toss in an argument for source of income discrimination, but we'll get to that later in the presentation. All right, these are ways that types of prohibited conduct under the fair housing laws. People can engage in intentional discrimination, which means treating a member of a protected class or a person associated with a person of that class differently from other people. For instance, not renting to someone because they have a disability or because of their membership in any other protected class. And then disparate impact discrimination, which is it doesn't sort of look on its face to be discriminatory, but it has a discriminatory effect. So an apartment complex that has an extremely strict set of rules that would only apply to tenants with children, like no playing in common areas, might be considered a disparate impact discrimination, since although the rule applies to all residents, it really only affects residents that have kids. So that could amount to disparate impact discrimination based on familial status. Next slide. And then prohibited conduct in sort of another frame. Sexual harassment and discrimination against DV survivors are types of behavior that tenants may encounter that typically meet the standard of discrimination against a protected class, even though, you know, the phrases themselves don't necessarily name the protected class. So sexual harassment is defined in federal law as a form of sex discrimination. And historically, the courts have recognized two types of sexual harassment as forms of discrimination that violate the Fair Housing Act. The first is hostile environment sexual harassment, where a housing provider or agent engages in sexual behavior that seriously alters the terms or conditions of a tenancy, resulting in a hostile living environment for the victim. For instance, refusing to make repairs to a unit because a tenant refused sexual advances. And then the other form of sexual harassment that the courts have recognized in this context is quid pro quo harassment. This literally is just a Latin translation for this for that. I feel like, okay, and that's when a housing provider or their agent imposes conditions on housing based on a victim's submission to some sort of sexual advance or harassment, like providing housing in exchange for sex. And regardless of whether the victim in one of these instances experienced an actual loss of a housing opportunity or an actual economic loss, they can file a claim to report instances of that harassment. discrimination against domestic violence survivors is typically falls under a protected class because policies that discriminate against DV survivors. I'm sorry, I started that sentence in the wrong place. Because the overwhelming majority of DV survivors are women, they are protected by the Fair Housing Act's prohibition on sex discrimination. And policies or practices that target or discriminate against persons because of their status as DV survivors are likely unlawful under federal law. It's possible that a nuisance ordinance or a crime-free ordinance that a lot of localities pass, which often pressure landlords to evict survivors for calling the police too often, for instance, may also amount to disparate impact discrimination. Persons who feel that they are being discriminated against, either intentionally or through disparate impact policies, or who are experiencing sexual harassment may file a complaint with HUD, the Department of Housing and Urban Development, or DFEH. Or you can refer them to Bay Area Legal Aid, and we may be able to assist if they're eligible for our services. Someone has their hand up. Do you have a question?
Hi, yes, this is Marcus from Calabasas in Santa Clara. You hear about all kinds of harassment. It sounded like there are times when some landlord will literally refuse to fix something that's broken because someone refused that person. You know, they made an advance at this tenant and the tenant said no, so they refused. I mean, that is so sick, but I'm just trying to, I've heard of all kinds of harassment. That's one I'm not familiar with. It's horrible, but is that pretty common? I mean, that one just like, there's a lot of rotten stuff that goes on, but I'm just wondering, that goodness gracious, I wonder how often that kind of thing happens.
Yeah, I mean, unfortunately, it does happen, and we had clients who have experienced this. So it is, disgusting that there is this type of sexual harassment that goes on in housing, not doing repairs because maybe someone said no to them on their sexual advances, or just kind of creating this type of hostile environment, commenting on their appearance, making these types of unwanted remarks based on their sex. And unfortunately, we've had clients in this situation, and
Wow.
it is difficult, and sometimes people do not want to come forward because they are scared of retaliation. But it is unlawful for a landlord to retaliate against someone for asserting their rights. And in these types of situations, tenants can enforce their rights by filing a HUD complaint or a DFH complaint, and they would be protected from retaliation.
Okay, all right. And I'm wondering if there's anything we can do, our team can do, if we're trying to help somebody get housing. We're a permanent housing site, but of course, if people leave our site, we're trying to get them into really, some housing that may last 5 years or 10 years or something like that. I'm just wondering if we know people and have a relationship with them, is there anything that we can do that would make it a little bit more likely that they would confide in us? That you are not going to believe what the maintenance man said. You're not going to believe what the landlord said to me. That kind of, because I would imagine people wouldn't want to share it, but I'm just wondering, if there's anything we can do. I'm just asking that.
Yeah, and I think that's a good question. I think one thing that is very important in these types of situations is to document, and if there's any documenting what happened, who was there, what time it was, who else heard, and being able to provide that log. Sometimes clients aren't able to have that documentation with them. But
Right,
if they are able to
right.
meet someone and have a copy of that text message, or if they're able to email somebody and have a copy of that email, just listing out what happened. And that's good if they're trying to enforce their rights, because then they have a documentation
Yeah,
of when it
yeah.
happened, and then
Yeah.
can provide that as evidence when trying to enforce their rights.
Okay, thank you. And I hope I'm making it clear. I think it's horrible if it's ever happened to one human being in the last 300 years, but thank you very much. This is heartbreaking, but helpful.
Yeah, thank you for your question. We have another question, Rosalia.
Thank you so much. And I know you have to get up with the presentation, so I'll be very quick. I'm helping several families that are actually going through different situations, including one's sexual harassment. And they did everything that they want, but my concern is the little window in between they making the report, the investigation, and then the landlord finding out that there is an investigation, but nothing has been resolved yet. And during that time, we're getting a bunch of retaliation. So it's still very dangerous for the families when they come up and try to report something, even if they have the proof, because there's still that little window in between the investigation when the landlord or whoever is doing this situation, it's making them having an even worse time than what they are having already. So I think, I hope that one day we will have a procedure that protects them during that time of investigation, but it's still very, very difficult for families to come up and say, this is happening to me. I just wanted to bring this one up to the group. Thank you for letting me share.
Of course, no problem.
Thank you.
Thank you for sharing that. And then also, just as an overall, we cannot provide, specific legal advice. If there are tenants in certain situations, they can definitely contact our legal advice line and see if they're eligible for services to provide, so we can provide them with advice. And this presentation is just for information only. So I know there's sometimes, specific legal questions that relate to a specific client of yours, and unfortunately we can't provide advice. We can just provide general information. So next slide, please.
All right, hypothetical. A developer constructing a building puts out applications for new properties. As part of the application to rent, the developer states that each person needs to be gainfully employed as a measure to ensure residents could afford to pay. The policy had a discriminatory effect on people with disabilities because they are more likely to be unemployed and receive income through means other than employment, like SSI or SSDI. So what type of prohibited conduct is at issue here? All right, that's about half of people. Just a couple more seconds before we end the poll.
And there was, I believe, a question earlier about discriminatory advertisements. So discriminatory advertisements can also be enforced with HUD complaints or DFVH complaints, we believe.
Okay. Poll results are actually very evenly split. Y'all said half of you said intentional and half of you said disparate impact. I think that's probably a result of the fact that those of you in this training are more than average attuned to the obstacles to that appear for people with disabilities. But to a court, this would appear to be disparate impact discrimination because it doesn't specifically say the word, no disabled people. or something like that. All right, next slide. All right, so take a look at this ad that we have screenshotted here, and just type in the chat what type of discrimination you think this ad is, intentional or disparate impact. And we are getting a lot of intentional, which is correct. This is intentional discrimination. And then now for the next question, what protected classes are being discriminated against here? There's a number of, category. Yeah, there we go. Yeah, we have a lot of good answers in the chat. Yeah, race, color, national origin, and ancestry are all implicated by this ad.
Nice. Thank you guys all for your answers in the chat. So next, we'll talk about reasonable accommodations. On the next slide, please. So what is a reasonable accommodation? So a reasonable accommodation is a change in a rule, policy, practice, or service that is necessary to allow a person with a disability the equal opportunity to use and enjoy a dwelling or their housing or their residence. So what constitutes a disability under fair housing laws? So what's a disability is a very specific legal analysis where there is either a mental or physical impairment that either substantially limits or limits one or more major life activities. So there's a difference between California law and federal law. Under federal law, like the Fair Housing Act or the Fair Housing Amendments Act, a disability needs to be an impairment that substantially limits a major life activity, while as under California law, it doesn't need to have a person doesn't need to have a substantial limitation. It just needs, the impairment just needs to limit one or more major life activities. And what is a major life activity? A major life activity includes like breathing, walking, sleeping, talking, working, taking care of oneself. That is a major life activity. A person can also be disabled, considered disabled under fair housing laws if they have a history of having such an impairment, or if they're regarded as having such an impairment. So earlier in one of the hypos, we discussed, I think Tammy Tennant, the protected landlord didn't want to rent to her because he perceived veterans to have PTSD. So even though maybe Tammy Tennant didn't have PTSD, that landlord perceiving her as having PTSD would be discrimination based on a disability. So one doesn't need to have it, but if they are regarded as having that impairment or perceived to have that impairment, that would constitute disability under fair housing laws. Next slide, please. So reasonable accommodation denials. So a reasonable accommodation may be denied if a person is not disabled under fair housing laws. So if that person doesn't have an impairment that limits or substantially limits a major life activity, then that person is not considered disabled under fair housing laws. So for example, maybe a person requests an exception to a no pets policy as a reasonable accommodation, but they don't have any health impairment that limits a major life activity and is unable to provide any verification of this, then they would not be entitled to an exception to that no pets policy. Also, a reasonable accommodation may be denied if there is no nexus between the disability and the requested accommodation. So what this means is that there's no connection to what the accommodation requested is to that person's impairment. So for example, if someone with a hearing impairment requests a parking spot closer to their unit if there's assigned spaces and they want a closer parking spot. Absent making that connection between why the accommodation requested a closer parking spot is connected to that hearing impairment, that wouldn't be, it's generally not connected unless there is some sort of verification that they can provide that there is a connection. But absent that connection, a reasonable accommodation can be denied. And, as housing advocates, we try to be creative to make that connection. I see someone put in, "You need to hear the car alarm." That's that could be one.
That's an argument you could make.
That definitely is an argument you can make. Again, as housing advocates, we try to be very creative in making that connection between the disability and the requested accommodation, such that a person with a disability can use and enjoy their dwelling. But if there is no nexus, then the accommodation will likely get denied. An accommodation can also be denied if the request is not reasonable. So what's not reasonable under fair housing laws is whether it's the reasonable accommodation which would result in an undue administrative or financial burden. And what an administrative or financial burden is needs to be determined on a case-by-case basis. So just because a housing provider may need to pay some out-of-pocket expense, if the accommodation is approved or granted, it doesn't mean that the reasonable accommodation has an undue financial burden. So the operative word here is undue. It needs to be an undue burden. And what undue is based on various factors. And these factors include the burden, what the cost of the reasonable accommodation is, the resources of the housing provider. So if it's a larger housing provider who may have a lot of resources, then that needs to be taken into consideration, whether it would have an undue financial burden for the reasonable accommodation. Also, another factor to consider is the benefit the tenant would have if the reasonable accommodation was granted, and whether there are any other alternative accommodations that could be approved. And lastly, a reasonable accommodation can also be denied if it would alter the nature of the provider's operations. So a fundamental alteration means that the request would change the essential business of the housing provider. So for example, there's a tenant with a mobility impairment, and they have difficulty getting groceries, and they make a reasonable accommodation request for the housing provider, maybe the property manager, to assist them in getting groceries and do their grocery shopping for them. So this would change the fundamental nature of the housing provider, because the housing provider is in the business of renting units. They're not in the business of a grocery delivery service. And so that reasonable accommodation request would, if approved, would change the fundamental nature of that provider's operations. So that's just an example of why a reasonable accommodation could be denied. Next slide, please.
All right. How to go about requesting a reasonable accommodation. You are entitled, a tenant is entitled to request a reasonable accommodation either orally or in writing. But as an attorney, I always strongly recommend that you make the request in writing, or at least if you make the request orally, that you follow up with written confirmation. I think Laura already talked in some detail about how your request must state a nexus between the disability and the requested accommodation. You know, the clearer you can be, the better. You are not obligated to attach verification from an eligible professional with your reasonable accommodation request, but the landlord is entitled to request that verification. So in order to streamline the process, we often recommend that people just provide that verification upfront along with the initial request, to reduce the landlord's opportunities to create obstacles. Even if a tenant requests an accommodation that the housing provider thinks is not reasonable, the housing provider can't just say it's unreasonable, we're not granting it, end of story. The housing provider has an obligation under the law to engage in an interactive dialogue with the tenant to get more information about the disability and the specific need, and to find an alternative that is reasonable within the housing provider's capacity and still satisfies the tenant's need. If a housing provider denies a reasonable accommodation, that can be discrimination, again, depending on the facts of the case. And if a housing provider just ignores or delays for a long time their response to a reasonable accommodation request, that may count as a denial. If there's a denial or a functional denial of reasonable accommodation request, the tenant can seek enforcement through a HUD complaint or a DFEH complaint. All right, next slide. Oh, sorry, here we go. True or false? Somebody with a mobility impairment can request a parking spot closer to their unit as a reasonable accommodation. Give it a few more seconds. All right. Well, everybody that answered got the answer right. Yes, this is true. So good job, everybody. Next slide. True or false? Somebody who has a hearing impairment can request a parking spot closer to their unit as a reasonable accommodation. All right, just a few more seconds to get your answers in. All right, we've got a little bit of a split on this one. About 2/3 of you said false and 1/3 of you said true. I guess we could have phrased this one a little better. Anyone can request a reasonable accommodation, so in that sense it's true, but it's unlikely to be approved, and you would have a harder time demonstrating a nexus to a court if you had to bring it to someone for enforcement, because there's not an obvious connection between sort of like a mobility question and a hearing impairment. Did that? Yeah. All right. Next slide. One more hypo on this topic. True or false? A person with a mental health impairment received a notice of lease violation due to symptoms of her or his disability. The person can request that the notice be withdrawn as a reasonable accommodation.
There was a question in the chat. We can't provide any specific advice, but generally, and what our practice is we obtain the verification from a knowledgeable professional and attach it to a reasonable accommodation request and provide it.
Okay.
and provide it to the housing provider. Generally, if there's any issues, I guess, to the authenticity of the verification, then they can, reach out to the doctor, the knowledgeable professional, to make sure, they did provide that verification. But generally, we haven't had any issues with them accepting it, just because it came from us and not directly requested on the basis of the housing provider, if that makes sense. And Housing Authority is also pretty good. When we ever request reasonable accommodations to the Housing Authority, they accept our verifications that we obtain from a knowledgeable professional.
But just to discourage rejection of documents and to discourage landlords from questioning authenticity like that, you can ask the doctor that the doctor either put their statement on, their office's letterhead, so that there's a clear way for the housing provider to contact the doctor and be like, is this really you? Or otherwise verify it on their own if they're really that worried. All right. Poll question, poll answers. Almost all of you answered true. This person can request that the notice be withdrawn as a reasonable accommodation, and that is correct. Yeah, if the landlord is alleging that your disability symptoms constitute a lease violation, then you can request that decision be withdrawn as disability discrimination. Next slide. Housing providers' obligations. And we touched on this a little bit earlier, but if a housing provider believes that a tenant's requested accommodation is not reasonable, then the housing provider and the resident are obligated to engage in interactive dialogue so that they can get more information about the disability-related need and find a reasonable way of satisfying that need that the housing provider can accommodate. As a part of this interactive process, the housing provider is supposed to recognize that the individual requesting the accommodation is the most familiar with his or her disability and is in the best position to determine what type of aid or service will be effective to meet their need. A housing provider has an obligation to provide prompt responses to reasonable accommodation requests. And again, an undue delay in responding to a reasonable accommodation request may be deemed a failure to provide the reasonable accommodation. Similarly, a failure to reach an agreement on an accommodation request after the interactive process is an effective decision by the provider to not grant the requested accommodation. It may be considered discriminatory if a housing provider denies a reasonable accommodation. If that happens, the resident or tenant has the ability to seek enforcement of the fair housing laws, again, through a HUD complaint or a DFEH complaint. Next slide.
Nice. So now we'll talk about some examples. And just to add to the question that was in the chat, a housing provider doesn't have to have an official reasonable accommodation procedure or policy on how to deal with reasonable accommodations. Some housing providers do to streamline any reasonable accommodation requests that come in, but there doesn't have to be an official policy in order to meet the requirements under the law. So like Anna just explained, there is that duty and obligation to engage in the interactive process, whether or not a housing provider has a procedure or policy for doing so. So now just some more reasonable accommodation examples that we see frequently. So I think we went over this in the hypo, but there's a parking space and maybe a housing provider has a policy of unassigned parking spaces, and residents can take parking spaces on a first come first served basis. But there's a tenant with a mobility impairment that needs a parking space that's closer to their unit, and their impairment substantially limits their ability to walk. And so in this case, there's that nexus. So the housing provider must make an exception to its unassigned parking spaces policy and provide a parking space to accommodate this resident. There's also some no pets policies that we see frequently, where a housing provider has a no pets policy, but there's a tenant with a hearing impairment that has an assistance dog, and as a reasonable accommodation asks to allow them to have this dog. This dog, alerts the tenant to sounds, knocks on the door, smoke detectors, fire alarms. And so in this situation, a housing provider should make an exception to their no pets policy. There is also an example where there is a no pets policy, but there's a tenant that suffers from depression and uses an emotional support animal to cope with symptoms of their disability. And in this situation, the housing provider must also make an exception to its no pets policy. Next slide, please. So true or false, it is unlawful discrimination for a housing provider to not respond to a reasonable accommodation request. So apology for the double negatives here. All right, just a few more seconds. All right, so yes, the majority said true. So that's correct. It is unlawful discrimination for a housing provider to not respond to a reasonable accommodation request. As Anna explained, the housing provider has an obligation to at least enter into an interactive process. They can't just not respond to a reasonable accommodation request. Next slide, please. So next, if a housing provider waits 3 months before responding to a reasonable accommodation request, the reasonable accommodation request may be considered denied. True or false? A few more seconds. All right, very close split here, 49% to 51%. So we would actually consider this to be a constructive denial if a housing provider didn't provide a response within 3 months. Again, that 3-month period is a long time for a person with a disability who is not afforded their ability to use and enjoy their dwelling because they don't have the accommodation granted.
Someone in the chat is asking, when a landlord responds to a reasonable accommodation request, are they obligated to do it in writing? I am not aware of an obligation for the landlord to respond in writing, but if you're a landlord orally denies a reasonable accommodation request and there is no written statement of it, it is definitely in the tenant's interest to create a writing and basically say, landlord, I received, we had this conversation on this day in which you told me that you would not be granting this request, right? If the landlord doesn't document it, then the tenant absolutely ought to.
And so next typo, true or false, if granting the reasonable accommodation costs the housing provider money, the housing provider can deny the request. True or false? Let's give it a few more seconds. Okay. So majority said false. Again, whether an accommodation, a reasonable accommodation request cannot be denied simply because it costs the housing provider money. It needs to be determined whether there's an undue financial burden. And what's undue, again, it's based on certain factors, including the cost of the accommodation, the financial resources of the housing provider, the availability of other accommodations, and the benefit to the person requesting the reasonable accommodation if the reasonable accommodation was granted. So again, there needs to be that case-by-case determination made, but simply just because it would cost a housing provider money, they can't deny it simply for that fact. Next slide, please.
Source of income discrimination. Next slide. I hope you guys can't hear. I don't know. There's some like large truck outside my window. I hope that's not getting into the audio. Source of income is now a protected class in California. So landlords are required to accept housing subsidies, whether they're federal, state, or local public assistance subsidies, as part of a tenant's income. And they can't refuse to rent to people because on the basis of them having a housing subsidy or rental assistance. This includes tenants who are on Section 8, tenants who have HUD-VASH vouchers, and other forms of rental assistance. And with respect to the HUD-VASH voucher, denying somebody on the basis of that would be like a triple whammy, because military status and veteran status are also independently protected classes under California fair housing law. If a landlord discriminates against a tenant based on their source of income, the tenant has a right to file a discrimination complaint with the Department of Fair Employment and Housing. Unfortunately, nothing in this law prevents a landlord from requiring a tenant with a voucher or rental assistance from meeting other sort of like tenant qualification criteria, such as like a certain credit score or rental history. So landlords are still able to sort of use those other pieces of information as proxies for voucher holders. There's nothing we can do about that at this point. Next slide. All right, take a look at this housing ad. True or false? This housing ad is lawful. Do we have a poll that people can click on, or should they put it in the chat? All right, there we go. All right, get your answers in. Okay. So most of you said false. This ad is not lawful. And that is the correct answer. The ad says not accepting Section 8. And the law is pretty clear that it is unlawful to make, print, publish, advertise, or disseminate in any way a notice, statement, or advertisement that indicates a tenant will be rejected because their source of income includes a Section 8 voucher. Let's see. People are asking in the chat, what can you do where a landlord says that they're not accepting vouchers? Ideally, get legal, call legal aid, or a private attorney if that's in the tenant's capacity. And ordinarily, the attorney would start by writing a demand letter to the prospective landlord explaining the state of the law on that matter. And hopefully the landlord will fall into line. But whether or not you have access to an attorney or whether an attorney assists you with it or not, a tenant can file a complaint with the Department of Fair Employment and Housing against that prospective landlord. And if the statement the landlord made was in writing, like this ad or something like it, that is great. Absolutely report them and include that in your DFEH complaint. DFEH will likely not move fast enough to get your prospective tenant at a particular unit into that unit, but it'll create they may ultimately punish the landlord and cause the landlord to comply with the law in the future.
Yeah, and unfortunately we have, we still see source of income discrimination. And just for our purposes, I know some people have mentioned that they see it all the time as a housing specialist. Could you enter in the chat if you've seen this recently? Thank you.
All right, next typo. A 2-bedroom unit is advertised at a rent of $2,500 a month. The building has a policy that all households must have an income of at least 3 times the rent to qualify for a unit. A household with a Section 8 voucher applies for the apartment. The tenant's portion of the rent would be $300. Is the housing provider permitted to require the tenant to have a monthly income of $7,500? Yeah, sorry. Yes or no? All right. Any last people want to answer the poll? Great. So most of you said no, and that is the correct answer. DFEH has put out like a flyer that addresses this issue. If a tenant is using a housing subsidy, the housing provider is only permitted to consider, when assessing a tenant's ability to pay, they're only allowed to consider the amount of the rent that the tenant is personally responsible for. So if a housing provider uses an income standard that's not based on just the tenant's portion of the rent, then the housing provider has committed unlawful discriminatory housing practice. So in this case, in these facts, the housing provider could demand that the tenant have an income of $900 a month, but they could not demand that the tenant have an income of $7,500. Next slide.
All right, so next we'll go over protections for immigrant tenants. There's also, someone asked in the chat if they can get a copy of this flyer with this information. There
I think
is,
I can link it, but go
Okay.
ahead.
Thank you, Anna. Yeah, there's a DFEH source of income FAQ that has that hypo as well. Thanks, Anna. So next, we'll talk about the Immigrant Tenant Protection Act, which provides just additional protections for immigrant tenants. So along with fair housing laws, there's also California protections. So California, in California, landlords are prohibited from asking a tenant about their immigration or citizenship status unless to comply with a federal government program or other legal obligations. So for example, those in federal programs are limited to generally citizenship status if United States citizens or lawful permanent residents. And so in that scenario where a landlord is trying to comply with federal regulations, they can't ask for this information. But generally, landlords are prohibited from requiring a tenant to make a statement, representation, or certification about their immigration status. And they are prohibited from disclosing any information relating to immigration or citizenship status for purposes of harassment, retaliation, intimidation, influencing a tenant to vacate the unit, or trying to recover possession of the dwelling. Next slide, please. So again, landlords are prohibited from evicting tenants based on their immigration status. If a landlord tries to evict a tenant based on immigration status, a tenant may use that as a defense in an unlawful detainer action. The next training will go over the eviction process overview and affirmative defenses. But here it would be considered a rebuttable presumption that a tenant or occupant has established an affirmative defense if the landlord did both of the following. So they first approved the tenant to take possession of the unit before filing the unlawful detainer action, and then included in the unlawful detainer a claim based on one of the following. So the failure of the previously approved tenant to provide a valid social security number, the failure of a previously approved tenant to provide information required to obtain a consumer credit report, or the failure at any time of the previously approved tenant to provide a form of identification acceptable by the landlord. So in all of these scenarios, there was a tenant that was approved to take possession, took possession of the unit, and then is being retaliated against and being evicted by not providing this information. So now we have a hypo. So Tammy tenant rents a studio from landlord. She has a green card. During her tenancy, Tammy's studio required several repairs. She provided written notice to her landlord, but her landlord did not respond immediately. After 3 weeks, her landlord stated that he would get a repair person out, but nobody came. So Tammy then went to code enforcement, and code enforcement investigated and ordered Tammy's landlord to make repairs. Tammy's landlord then gets upset and accuses Tammy of being undocumented and tells her that she needs to vacate immediately or, quote, go back to her country. Landlord then sends Tammy a text message threatening to contact ICE. So true or false, landlord engaged in unlawful retaliation. And then there's a question in the chat. How would you know that reason to ask is to abide by federal regulation? So generally, if it's a federal housing program, so for example, project-based Section 8, the housing choice voucher, there's the certifications, then they are, if there's like a HUD program or a HUD financing, then that could clue you into allowing generally housing authority to ask for that information. And then just there's the question, are there housing programs for those who are undocumented or those who don't require a social security number? Um, not too sure. There may be some non-federal programs who may not require a social security number, but not 100% sure on that question. And generally, landlords as well in California that aren't tied to a certain housing program, um, it it's based on a landlord can not require to provide a social security number. So 100% said true, which is correct. So good job, everyone. Yes, that is unlawful retaliation. Again, a landlord cannot threaten to contact ICE based on their immigration status, even though Tammy's not undocumented. That doesn't matter in this situation. And can use phrases like "go back to your country," which is discrimination based on perceived immigration status. So again, this is unlawful retaliation, and Tammy would also be protected under fair housing laws for unlawful discrimination and harassment. So thank you, everyone. That was all. If there's any questions, we have time for questions, and also a plug to please fill out the survey at I think it'll get popped up. Yeah, it's in the chat. So please fill out the survey. We really appreciate the feedback and how we can serve and provide these presentations. And if there's any questions, we have some time to take them. Or now you have time to fill out the survey.
I believe the PowerPoint will be emailed out.
Yes. Everyone will be notified when a PDF version of the PowerPoint and the recording is uploaded to the CSC training page. So you all will have those materials. Once again, thank you both, Anna and Laura, today. We hope to see you all next week for our last part of this series. And like they said, we do have some time if you want to ask questions, come off mute and ask your questions. Otherwise, please do fill out the feedback form.
Yes, happy Halloween. And then Anna also put a link to the source of income FAQ earlier on. You want to scroll up in the chat, or I don't know if Anna, you have that. Maybe I can copy. I can't copy the chat. If you have it, you can link it.
I just put it in again in case anyone lost it in the thread.
Awesome. Thank you.
The eviction process and the specific COVID-19, many changes in the law will be in our next week's training for those of you who are especially interested in those issues.
Then we had a question. Most low-income housing programs typically have the backing of federal funding. Yes, there are a lot of programs that receive HUD funding and other federal funding, but I believe there may be programs that may not, and maybe just have state funding. But I'm not too sure on what those specific programs are. But you're typically right. Typically, many low-income programs have federal funding. Yeah, lots of questions about COVID and eviction. Get your questions ready.